So the difference between direct evidence and circumstantial evidence, people ask that question. Those are terms that are in the popular culture for sure, and people want to know how that applies in the courtroom. When I first started practicing law in West Virginia, there was a difference legally. At the end of a trial, a judge, if I asked for an instruction to a jury, the judge would have to instruct the jury that circumstantial evidence is to be given not quite the same weight that direct evidence is. It's not as reliable, a judge would say. And we would ask a jury to consider that and say, hey, with the lack of direct evidence in this case, there's insufficient evidence to convict. Direct evidence would be a witness who can come into court and testify, I saw my neighbor, Mr. Jones, drive a blue Chevy away from the bank. Circumstantial evidence would be a witness saying, well, the blue Chevy was not in the driveway and Mr. Jones always drives it and I knew it was gone, and because I always see him drive it, I suspect it was him driving it. That would be circumstantial evidence. Well, right now in the law, there is no difference between the admissibility of those two pieces of evidence and whether how the jury should weigh it. Right now under the law, it's all the same. Be assured that there are a lot of people convicted of felonies in West Virginia and misdemeanors, many of whom unfortunately are inmates in our prison system, who were there solely on the basis of circumstantial evidence. In our practice, we are all trial lawyers in this firm, and we know how to make the argument to a jury that, hey, while it's admissible into evidence, it's really not something you should give the same weight as you give to direct evidence. A judge won't give that instruction, but we're certainly permitted to discuss that and argue it in front of juries, and we do that on a regular basis when it's appropriate. So when you're concerned about whether or not circumstantial evidence can get you convicted, the answer is absolutely it can. And as I said, a lot of people have suffered convictions based on circumstantial evidence alone. So it is important, if you're facing a criminal case, to get with a qualified trial lawyer, a qualified criminal defense lawyer. Call Arnold and Bailey. We know all the issues that would be existent in your case, and we can do the best to advocate for you, including representing you whether there's circumstantial or direct evidence.